Hello, I'm back again today. This is July 13th of 2026, and I'm here to talk about a major change to endangered species law that it will be published in the Federal Register tomorrow. So don't go turning this off now. The Federal Register is the official daily publication of the United States federal government. It is where the federal agencies and the President formally publish rules, proposed rules, notices, and presidential documents such as executive orders and proclamations. Today I will introduce the notice rescinding the definition of harm under the Endangered Species Act, Public Inspection Document 2026-14195 that is scheduled for publication in the Federal Register on July 14th of 2026. I want to hear your feedback about this one in the comments below. Please like this, circulate it to anybody that you think will want to know about this. It's a pretty big change. Each week I review some selected items from the Federal Register so everyone gets a no BS literal interpretation of what they are really doing and what the government officials may have said about it. I'm Dr. Malcolm McCallum. I hold a PhD in environmental sciences and have over 30 years experience teaching in higher education. As an environmental scientist, my role is to research, educate, and inform about how the world of humans and the world of nature interact. The umbrella of this is called the socio-ecological world, and that's where we reside as humans. The overarching purpose of this field, called environmental sciences, is to protect everyday people and the natural world from the rich and powerful. So I believe by just explaining what news items appear in the Federal Register, that I will be informing everyday people what the government is really doing if they are working for you or someone else. Remember to hit the like button again and subscribe so you'll always be in the loop. At the end of the video, there's a little icon there that has a thumbnail you can hit. And this is a really good place to learn about what's really going on in the executive branch in particular, that they may want hidden by distraction campaigns on TV and radio. So let's start going over this document. Okay, so the title of this document is, just a second. The title of the title is going to be rescinding the definition of harm under the Endangered Species Act. This is being issued by the U.S. Fish and Wildlife Service, Department of Interior, and the National Oceanic and Atmospheric Administration and the Department of Commerce. This is a final rule. The portions of the Code of Federal Regulations that will be affected is 50 CFR Part 17 and 50 CFR Part 222. This is dockets number Fish and Wildlife FWS-HQ-ES 2025-0034 and NMFS-250411-0064, as well as RIN 1018-B 138 and 0648-B N93. There will be a hyperlink there where you can read it. The contact person is John Turpak, Acting Assistant Director of Ecological Services. His phone number is 703-358-2171. The email address is adecologicalservices@fws.gov. The subject line for any communications and the email should be 1018-B138. That may be a BI38. They're using Arial font, so no one knows what it says. The signers of this are Kevin Lilly, Principal Deputy Assistant Secretary of the Fish and Wildlife and Parks, exercising delegated authority. Timothy R. Petty is the Assistant Secretary of Commerce for Oceans and Atmosphere, and Deputy NOAA Administrator. Those are the signees. So in a brief summary of this document, The final rule removes the regulatory definition of harm from the Endangered Species Act. That means this removes implementing regulations used by the U.S. Fish and Wildlife Service and the National Marine Fisheries Service. Under the prior interpretation, harm included significant habitat modification or degradation when that modification actually killed or injured listed wildlife by significantly impairing essential behaviors such as breeding, feeding, sheltering, spawning, rearing, or migrating. That's about their whole darn life, okay? There isn't much else wildlife and fisheries do. The services now rescind that regulatory definition from 50 CFR Part 17 and 222 and state that the statutory definition of take will stand on its own. Meaning that if you don't obviously kill the animal or the plant, it wasn't killed. And if nobody's monitoring it because they've already fired everyone, nobody knows about it, it didn't happen. Think COVID, okay? How this changes previous policy. This is a major Endangered Species Act enforcement change because the old regulatory definitions applied a bridge between habitat destruction and Section 9 take liability. If habitat modification actually killed or injured listed wildlife by impairing essential behaviors, the old rule allowed the services to treat the habitat modification as harm and therefore as prohibited take. It's no different if someone blows up your house in the middle of winter and now you have nowhere to live and you freeze to death out there. Did they kill you? Of course they did. That's what's going on here. No longer. Now someone blows up your house and you die because you froze to death. Well, too bad. Something you should expect from billionaires and the super rich, I suppose. How this changes previous policy. Well, I've already talked about that. Okay. Okay, where was I? The new rule... So the rationale for this change ought to be interesting. The service's legal rationale rests heavily on the end of the Chevron deference after the Loper-Bright. They argue that Babbitt versus Sweet Home upheld the older habitat inclusive definition as permissible agency interpretation, not necessarily as the best reading of the Endangered Species Act. The final rule adopts Justice Scalia's Sweet Home dissent. Justice Scalia's Sweet Home dissent, concluding that the take should be read as affirmative conduct directed against a particular animal rather than indirect habitat effects on a population. This is utter nonsense from a biological standpoint, but from a legal standpoint, I suppose it holds. The services also conclude that keeping only the first sentence of the former regulatory definition would create uncertainty because the old definition operated as an integrated interpretive framework. They therefore rescind the entire definition rather than replacing it with a narrow definition. Of course they do, because they don't want to have to deal with endangered species. If they die, these people will be able to just sell off the land, destroy it, drill it, whatever, because that's really all they're interested in. Economically, the rule is framed as regulatory. The services estimate annualized quantified cost savings of $361.3 million at a 3% discount rate and $521 million at a 7% discount rate, reflecting reduced planning, negotiation, migration, and implementation costs for habitat conservation plans. Of course, anyone with a background in economics knows that this is absurd because it doesn't take into account the loss of species, the loss of individuals, the loss of habitat, the damage of habitat, the damage of natural world, the damage of recreational value, the damage of sports activities, the damage of everything that goes into these habitats. Never mind the backdrop that causes it to impact all of the natural world around us, which feeds back into the social world in which we reside, which means that it's a big, huge, giant mess. Public comments and procedural context. By the close of the May 19, 2025 comment period, the services received approximately 358,000 public comments. Commenters included individuals, states, tribes, industry organizations, legal foundations, and firms and environmental organizations. The services received requests for public hearings and an extended comment period, but the but declined both and extended comment period, but declined both, concluding that hearings were not required and that 30 days provided enough time for meaningful comment. That's because unless you're going to make them money, it's not meaningful. Some people need to be getting out to their lawyers. The services acknowledged that many commenters argued the rescission could weaken the Endangered Species Act habitat conservation, reduce incentives for habitat conservation plans, increase unpermitted take, and create regulatory uncertainty. The services responded that Section 9 and Section 10 cannot be used to require habitat mitigation obligations that, in their view, are not authorized by the statute. Nothing's authorized by the statute from these people unless it makes them money. Keep that in your context, everything makes sense. So what are the Democratic and Republican viewpoints? Try to stay objective here, which is going to be hard for me because I actually know something about this. The Trump administration, through Interior and Commerce, presents the rule as restoring the Endangered Species Act to its actual text and original intent, extending what it calls years of federal overreach, reducing regulatory burdens, and protecting private property. I think that President Nixon, who was very proud of his environmental legacy, would not agree with this. Interior Secretary Doug Burgum described the prior interpretation as a regulatory trap, while Commerce Secretary Howard Lutnick framed the change as conservation without sacrificing economic growth. By definition, conservation considers economic growth. This sacrifices conservation so that we can have a lot of economic growth and let everything die. This is a path to Soylent Green these people are putting us on, and this is only one of the things they've done just this year. At the congressional level, House Natural Resources Committee Chairman Bruce Westerman of Arkansas has argued for broader Endangered Species Act reform. His stated goals include clarifying definitions, streamlining permitting, increasing transparency, reducing litigation-driven implementation, and focusing on the statute on species recovery. Of course, never mind that they closed hearings, had no additional time for public comment. So where exactly is the transparency? The transparency is within their group. The rest of us don't matter. Now, I realize everyone may not think this is important, or they may not care. Well, everybody's got different values, but in fact, this is a very, very extreme change to things that have been kept in place by even the most conservative and of Republicans who have been in office, and arguably presidents who were very successful and well respected. The Democratic viewpoint. House Natural Resources Committee ranking member Jared Huffman of California strongly opposes the rule. He characterizes the change as a move that would allow special interests to destroy imperiled species habitats and argues that the rescission is untethered from science and law. This is true. Being a person with a PhD in environmental sciences that looks at both the human and the natural world, it is very clear that what he's saying here is true. I mean, it just is. If you've had economics, policy, and ecological courses, you're going to know that it's about as obvious as it can get. State-level Democratic and allied state officials also opposed the proposed rescission. 16 attorney generals, led by Massachusetts Attorney General Andrea Joy Campbell, California Attorney General Rob Bonta, and Maryland Attorney General Anthony G. Brown submitted comments arguing that the existing definition is legally sound, scientifically grounded, and essentially because habitat modification can kill or injure listed species by impairing essential life functions. I did not find a strong notice-specific statement from a named local elected official, but this is primarily a federal policy and federal law controlled and run by the federal government, so that's not a surprise. The record of identified political viewpoints is strongest at the national and state levels, as you should expect for things that involve the Endangered Species Act. The scholarly and legally the background supporting the conservation and, frankly, the democratic position on this is the strongest scientific argument against the rule is that habitat loss and land sea use change are among the dominant drivers of biodiversity decline. This is There is not a scientist in the world who studies biodiversity that does not know this is a fact. You can create libraries of documentation of this. If you don't have a place to live, you're going to die. If organisms don't have a place to live, they're going to die. And once they're gone, you don't get them back. This has been identified. Land use and sea use change is a direct driver with the largest global impact on nature, and later science advances, the synthesis, that's a journal, similarly found that land and sea use changes are dominant recent direct drivers of global biodiversity loss. Now understand that we're losing biodiversity at monumental levels. Pym, Barnowski, myself have all published papers using different methods that come up with the exact same results. We are trashing trashing the environment, and we're losing biodiversity. And that biodiversity is crashing at alarming rates, and none of these people care. Greenwald and colleagues estimated that the Endangered Species Act prevented roughly 291 extinctions and saved more than 99% of listed species from extinction, indicating the importance of a strong legal tool and tools in preventing species loss. Legally, the strongest conservation side support is Sweet Home, in which Supreme Court upheld the regulatory definition that included significant habitat modification and degradation when it actually kills or injured wildlife. This has already been addressed by the freaking Supreme Court. Scalia had a dissent, and they're following his dissent. That's it. One guy writes it down, the rest of them all agreed. Well, they're going with the one guy because it makes them money. That's it. It makes them money. And it doesn't make you money. Remember that, too. The background supporting the deregulatory and Republican position on this. Well, the strongest policy argument for reform is that the strict habitat-based regulation on private lands can create perverse incentives. Perverse. Remember that. It isn't perverse, but they contend it's perverse. Luck and Michael found evidence that some landowners preemptively destroyed or harvested red-cockaded woodpecker habitat to avoid regulatory constraints. This here is perverse, okay? And I've seen similar things. When I worked on Illinois chorus frog, we met with the NRCS office, and after we met with the NRC office, everything seemed fine. NRCS was fine. Then the private parties decided to go level all the soil they could, and pretty much drove the animal out of, just devastated the limited population in Arkansas. Now that was a state level issue more than a federal. But anyway, these things do happen, but it actually isn't that common overall. Usually people care about the environment in which they live, and they want to see that, they think it's kind of cool to have stuff around them that maybe is part of the natural world. But hey, there's greedy people all around. The stronger version of the reform argument is not that habitat is unimportant, rather that it is habitat conservation on private land that habitat conservation on private land may work better when landowners have clear rules, incentives, safe harbor agreements, and predictable permitting pathways rather than open-ended liability. There is no open-ended liability. This is bunk. There are very simple rules. If you buy a farm, you have endangered species review within your environmental site assessment, which I talked about that in an earlier one of these reviews. They want to remove that to improve, to give everyone a better ability to buy land, to buy properties to build houses. And then the person buying the houses ends up with the liability. This is one of those disinformation types of approaches that are used, that people who they don't want to do it, so they just say it's not fair, it's not good, it's bad, it's crooked. But in fact, it's not. It's held up to, 1970s when this was passed. And it's lasted for decades, and everyone knows how it works. Every business knows how it works. It's not some kind of a cauldron of emptiness with no answers. Okay. The species most and least affected by the rescission of the ESA harm definition are not necessarily the rarest endangered species, the rarest listed species. You have to remember that organisms that are deemed endangered or conservationally relevant, regardless of whether it's state or federal level or other types of areas, these species are put on there because their populations may be failing, the extent of their range may be super small compared to what it once was. They may only occur in one little place in the world. And so there's a lot of different reasons that organisms are on the Endangered Species Act. It's not just rareness, though. Some things that actually you'll see them, but they're still protected under it, because if they remove the protections, the population's going to crash, because the protections are what are keeping that species present in the wild. And probably in captivity as well, if it is present in captivity. So, the most affected species and species groups from this decision, well, the sand skink and blue-tailed mole skink, they have very high likely impact. These occur in Central Florida they're Central Florida habitat specialists. They occur like lake walls, ridge scrub, and sandhill habitat. It's been heavily lost and fragmented. And the Fish and Wildlife Guidance indicates no designated critical habitat for these skinks. Habitat conversion can therefore be the main mechanism of injury. In fact, it's basically what happens. They destroy the habitat, the species disappears from that area. The Florida scrub jay also is likely to have very high impact from this. This non-migratory Florida endemic, whose primary threats are habitat destruction, fragmentation, and degradation from development and agriculture. That's it. Well, this just made it open season on Florida scrub jays. The coastal California gnatcatcher, which is another type of bird, will likely have less impact than those did, but it'll still be high nonetheless. These are closely tied to coastal sage scrub, a habitat heavily affected by urban and agricultural conversion. Large-scale HCPs, habitat conversion plans, conservation plans have preserved roughly 350,000 acres of coastal sage scrub for the species, showing the importance of the habitat-based permitting tools. So the presence of that is really why this isn't very high. The golden cheek warbler is at the same level. It breeds in specialized central Texas woodland habitats and continues to face habitat threat from urbanization, drought, fire, and other stressors. The marbled murrelet and the northern spotted owl, they're going to have high impact by this, but they're partly buffered by federal lands. Because this is a private lands issue at this stage. Both depend on mature and structurally complex forests. Timber harvest, land conversion, wildfire, and fragmentation are important habitat threats. Section 7 still matters where the federal lands or permits are involved. There'll be high to moderate effects on the red-cockaded woodpecker and other forest structure specialists. The woodpecker acts as an umbrella species to a whole array of organisms that live in the pine oak savannas of Louisiana and the southeast. I worked on red-cockaded woodpecker habitat with a former master's student, and we were able to see that the habitat where the woodpeckers were did have major differences in some of the biodiversity and abundance of individual organisms in those habitat restoration areas, but they only had very small areas. This was in the Kisatchie National Forest. This species depends on mature pine systems, and it's threatened by the lack of suitable roosting, nesting, and foraging habitat, fragmentation, and conversion. Additionally, freshwater mussels, species that live in springs, caves, wetland amphibians, and a small range of stream fishes. Stream fishes that occur in just a small range of areas. In fact, terrestrial organisms that have a small range, they're going to have, in many cases, have high impact from this decision. These species are often harmed by sedimentation, dewatering, groundwater withdrawal, channelization, pollution, and habitat degradation rather than obvious direct killing. You don't usually see someone running out and grabbing and smashing up freshwater mussels living in the bottom of a stream, but you do see them destroying the river, and that kills the mussels. The effect is reduced where a federal nexus still triggers Section 7 consultation, though. The least affected species among the endangered species are probably a lot of your Endangered Species Act listed plants. They have the lowest direct effect, and that's basically the Endangered Species Act take prohibition does not operate the same way for plants as for wildlife. Plants are the property of a landowner, whereas wildlife are the property of the state. That goes all the way back to, back to Rome. Certainly it's English common law that founded that within the American wildlife law foundations. Endangered plants on private lands can generally be taken. You can dig them up, you can burn them, you can do whatever you want. Whether that's morally okay that's a question for a different sort of thing, but legally you're allowed to. The only time you can't do that is if state law prohibits the activity, and some states do protect plants in the same manner as animals or in similar manners. Some other ones, the northern Atlantic right whale and similar marine mammals, they're going to have lower, but it's not going to be zero impacts from this. The species remains highly endangered, but its leading human-caused mortality threats are entanglement in fishing gear and vessel strikes, which are direct injury or killing problems and are also addressed under the Marine Mammal Protection Act. There'll be a lower relative effect on species primarily declining from diseases such as northern long-eared bats, which theirs is white nose syndrome. The northern long-eared bat faces extinction primarily from a range-wide white nose syndrome rather than habitat modification alone. Although habitat protection can still matter in certain areas. There'll be a lower to moderate impact on species whose conflicts almost always involve federal actions. Federal permits, federal funding, federal land management, federal dams, federal highways, federal energy approvals still trigger the Endangered Species Act Section 7 consultation and critical habitat analysis. So that's why these will have a lower to moderate impact. There'll be a lower impact on international captive trade focused or trafficked focused endangered species. These species, the main regulatory protections often involve import, export, interstate commerce, captive possession, or trafficking rather than U.S. habitat modifications. The bottom line, the rule matters most for habitat-dependent listed animals on private or non-federal land. It matters least where the main legal issue is direct killing, bycatch, ship strike, disease, plant protection, trade, captive possession, or federally authorized action already covered under Section 7. From a socio-ecological system relevance, this rule is highly relevant. Well, I kind of said that funny, didn't I? This rule is highly relevant to the socio-ecological systems that we reside in, both the social and the ecological world, because the changes in the legal relationship between species, habitats, landowners, developers, federal agencies, states, tribes, courts, and local communities. The ecological system includes habitat structure, connectivity, hydrology, food webs, breeding and rearing sites, refugia, migration corridors, and population viability. The social system includes property rights, economic development, litigation, conservation funding, environmental justice, tribal rights, agency capacity, and the public trust. Remember that environmental justice is about protecting the everyday people from the rich and powerful. And that's what that means. It doesn't have anything to do with anything else. The key feedback is that fewer habitat modification projects may require incidental take permits or habitat conservation plans. That may reduce short-term costs and delays for landowners and developers. But it also may allow habitat-based impacts to proceed unless another law, state program, federal nexus, or voluntary agreement captures them. So, the rule may shift conservation away from federal Section 9 take enforcement and towards Section 7. Critical habitat, state endangered species law, voluntary conservation litigation, and land acquisition. Looking at this from a component-by-component assessment, biodiversity and species recovery, this is very negative for habitat-dependent listed animals. Species that are habitat specialists, maybe sand prairie species, organisms that live in mountain streams, things like that, old-growth forests, organisms that need to be in a specific kind of habitat, like the rough edge of a forest bordering a grassland. It's especially a problem because this is where the main threat is private or non-federal habitat modification, and where direct injury is often pretty darn hard to prove. It's hard to prove, well, did that animal get killed because I cut down that tree, or that I leveled some property? It requires a lot of investigation, and that's hard to do when you're on private lands. Habitat and landscape connectivity, it's potentially negative, because habitat loss, fragmentation, and degradation may become harder to treat as a take. Because of this, the outside federal actions just aren't going to have as much of aren't going to be able to control this as much, and you start fragmenting these habitats even more than they already are, and you're going to see species extinctions, or at least they're going to disappear from the regions. Private landowners and development sectors, they are going to feel this is positive in the short term, though lower compliance costs, fewer habitat conservation plan obligations, and reduced regulatory exposure. So they're not going to have to do these things, and so it's kind of like if you're not taking vitamins and you need to take vitamins, well, you're not taking care of yourself, and so you're going to die. Well, if we're not taking care of the environment through these things, we're not going to have an environment. Not a natural environment, at least. It's just going to be a big mess. And we pretty much messed up enough as it is, I would think. States and federalism will have mixed impacts from this. States can maintain stronger laws, but states that do so absorb more administrative burden, while states with weaker laws may see weaker habitat protections. There's a bigger problem this. Many of our environmental regulations are at the federal level because environmental problems do not recognize state borders. And so, for example, air pollution, if I'm polluting in St. Louis, it's going to go on to the east side in Illinois. Okay? Federal regulations have to cover that. It's got to do with commerce and other issues. If an endangered species lives on one side of the border and it goes to the other side of the border, and on the other side of the border the state lets everyone shoot it, well, then it's not protected. Things like that. Okay? For tribes, this is potentially important, but exactly how it impacts them is not quite certain. The services concluded that the rule in general is general and does not require formal government-to-government consultation, but habitat impacts can still intersect with tribal lands, resources, treaty interests, and cultural values. Governance and litigation will have a very high impact. The final rule is likely to trigger litigation over Sweet Home, Loper Bright, reliance interests, arbitrary and capricious review, and NEPA compliance, frankly. This law is probably going to be paused. I would not assume that this is going to take place because there should be some major legal attacks on it, and appropriately so. I mean, maybe there's a good reason to have this be done, but I'm not aware of one. I'm aware of a lot of greedy reasons to have done. I'm not aware of any good reasons. And greed is not a good reason, at least not in my book. Now, if you're someone who's greedy, maybe you disagree. Mitigation and restoration impacts will probably be negative for habitat mitigation, conservation banking, offsets, and restoration markets built around habitat-based Section 10 permitting demand. The overall assessment of this, this is one of the most consequential Endangered Species Act regulatory actions in the current Federal Register stream. That should tell you a lot. Okay? The agencies frame it as legal correction because they're all appointed by the current administration who wants this. Okay? It is a very commerce-laden administration that has limited value placed on the natural world, except from a commercial standpoint, at least, or from a commercial standpoint would certainly be valid. The agencies frame it as legal correction, statutory fidelity, private property protection, and regulatory relief. But regulatory relief, let's face it, regulations protect someone from something. I would much rather have a regulation and have relief from having the rich and powerful walk over the top of my property and destroy it than have regulatory relief from problems that I really am never interacting with because I'm a small business or a small landowner. And for the most part, these regulations aren't a big problem for us. Opponents frame it as a major weakening of the habitat-based endangered species protection and a departure from decades of conservation practice. It's been done this way since day one. So saying that it was never meant to be done this way is literally not above board, okay? Opponents frame it as a major weakening of habitat-based endangered species protection and a departure from decades of conservation practice. Ecologically, the greatest risk is that of habitat loss, and we've lost a lot of habitat in this country. Almost every single square foot of old-growth forest has been cut down back going into the 1900s. Things like the passenger pigeon probably were more affected by the loss of old-growth forests than they were by the hunting. This habitat loss. It's the central driver. It's the organisms don't have a place to live, so they die. This is so simple to understand. And if you're going to destroy the place they live, you've killed the animal. Period. There is no other interpretation of this. Now, you may not care if the organism dies. That's a whole other issue. Okay? Politically and legally, the rule is a clear example of the post-Loper Bright shift towards reinterpreting agency authority through textualist statutory readings. This is a major, major change. It's not a change that we didn't see coming. This was telegraphed to everybody before the current administration came into power and was elected. And my gut feeling is that this is something that will, I don't see how the rule can even hold up for the long haul. It may hold up for a little while. If you're a business person who actually this does affect, it would be very wise to just follow the old rules until you find out what happens here. Because if you start altering all your actions to follow these new rules, you may find out that you're having to turn right around and go back to the way you did things before, and it's a lot cheaper not to change than to change things. That's something. This is not the kind of a rule that I would expect to last. It may last through this administration, but I would not expect it to. I don't even think it would last through another Republican administration. So that's enough for this. Be sure, if you don't like it, contact the people on this notice. It'll be coming out tomorrow. I'm not sure what the time frame is for comments, but they've already made the rule. It's done. So the only action here that can be done is to file major lawsuits by environmental organizations and maybe some wealthy people who actually care about something other than money. Those people do exist. They're around. It's not as rare as people think. And that's where we're at. Let's have a nice day, and please, if this concerns you, think about doing something about it by opening your mouth. Have a nice day.